Hi, my name is Nick Weiss. I am the founding attorney and managing attorney of NP Weiss Law in South Euclid and Elyria. I want to talk about real estate contract breaches. And in the context that we're talking about, areas where you can breach a real estate contract in general are a purchase agreement, that is to transfer a property, a loan around that property. We often call that a mortgage or a promissory note or a home equity line of credit. And finally, a lease, which is when you're renting out a property. There are other different kinds, but in general, those are the three big ones. You can absolutely buy property, rent property, and become indebted on property without ever consulting a lawyer. In fact, that's how most home purchases are done. You can also ride a bike without a helmet. You can also drive without a seatbelt. These are all choices that you can make. You can go through and do all of those things. We do not recommend that. Part of the reason that we don't recommend that is because of the high rate of failure for each of these types of documents. And there are a couple of things that you can do to prevent those failures and make sure that the contract goes through, or if the contract does fail, to mitigate your risk for that failure of contract. So let's start with an easy one. Let's start with a purchase agreement. The most common one that you're probably going to run into for a purchase agreement is for the sale or purchase of residential real estate, your house. And in general, the majority of those types of purchase agreements are either directly a form residential purchase agreement from Ohio's Association of Realtors, or a small modification to that an individual brokerage and individual real estate agency will be using, but they're all basically the same in Ohio. You'll basically have to kick and scream to get something different from that, and probably hire your own attorney to do that, because realtors do not like deviating from those contracts. Many times they can't deviate from those contracts because that would be the unlicensed practice of law. Common things in those purchase agreements, most important, of course, being the as-is portion in those purchase agreements, which means that you take the property as is, where is, no representations, no warranties. The only exceptions to that being the home disclosure statement that's part of your purchase, and any kind of inspection contingencies. Home inspections, please, please, please don't waive those. Please have them, right? They are not foolproof. Many, many times inspectors miss things, but it is your last and best chance to actually look at the property and see if it's something that you actually want to invest your time, energy, money, and life into. And importantly, if you waive that inspection, it becomes basically impossible to sue the home seller for an undisclosed defect in the property. We have another whole video about that, but it's extremely, extremely, extremely difficult. And you get the benefit of an inspection contingency. There are a couple of different contingencies in these agreements. Inspection contingency is one. Financing contingency is one. There can be a few others that you can freely negotiate as part of this. Lead inspection, asbestos inspection, things like that. These contingencies are very, very important because they give you an out if you find something. They give you a way to freely terminate the contract, not a breach, terminate the contract without any kind of penalty, get your deposit money back, what we sometimes call earnest money on the property back, and that's the only way to do it. If you don't have those things, and for some reason the deal doesn't go through, this is what we call a breach of that purchase agreement. So to breach a contract on the buyer's side, you are not buying the property and you don't have a good reason. You don't have a contingency in there that says, I get to not buy this property if X, if I find out that there's mold in the basement, if I find out that there's lead in there, if I find out that actually you don't own everything on the property that you said that you own, right? That's your breach, and that's what the seller can get remedy for. On the seller side, you breach if you don't sell the property. And there are very, very, very few times where there's a really, really good reason for not selling the property. And by really good reason, I mean one that a court would actually understand and forgive you for not selling the property. Buyers and sellers have different remedies. On the buyer's side, you can sue for breach of contract if that happens. Your remedies, though, are are pretty limited. You can certainly force the sale. You can have a court force the seller to sell the property to you and you buy the property from them. Courts in general don't like that. They don't like to force people to contract when they don't otherwise want to contract. So your other option is to sue for damages, to sue for money. That can be a little bit tough to calculate. It really is about the difference in value between what you would have bought, what you did buy, damages that you had because you had already set to move. And so you've got moving costs, you've got rental costs, et cetera, et cetera. But you do have things that you can go forward and try to claim. On the seller's side, you have the same things. You can try to force the buyer to buy the property. That can be very difficult. That can be difficult for a couple of reasons. The most important one is practical, right? A lot of times it's easier just to sell to someone else. And in fact, the first thing the court's going to ask you is, have you tried to sell that property? And if your answer is no, you're going to be doing an uphill battle immediately when you're trying to go through for all of this. The other thing that you can sue for is damages, is the difference, the price difference between your final sale, whatever that ends up being, plus your holding costs, and whatever you would have sold to the buyer. Real estate has a very narrow realm of damages. We call these compensatory damages, sometimes called economic damages. And we're looking strictly at dollars and cents with very, very, very limited circumstances. For a breach of a real estate agreement, you don't get things like emotional damages. It's not that kind of contract. You don't get things like punitive damages. Again, not that kind of contract. The court won't enforce it. And unless you've already put in the contract that the person enforcing it gets their attorney's fees, you don't get those either. So there's a lot of risk involved to trying to enforce one of those agreements, especially because, as we stated before, your standard purchase agreement isn't going to have any of those damages terms at all, especially those attorney's fees provisions in the event of a breach. Other things those purchase agreements don't generally have is, what do we do with the earnest money in the event of a breach? Those contracts are designed to protect realtors, not protect the buyers, not protect the sellers, right? Protect the realtors and protect the title company. So if the deal falls through and we've got $10,000 of earnest money, whoever's holding that money, whether it's the realtor or the title company, isn't going to give it up unless there's a mutual release by both parties or someone's got to sue each other. It's a really nasty pain point because someone's holding a bunch of money that could go back to both parties, right? So those are some of the things that you should look out for, some of the things that you should look at when you're looking at breaches of a real estate purchase agreement. On every single one of those steps, particularly making sure there are contingencies, particularly there are consequences for a breach beyond just everyone washing their hands and going home, that's where an attorney can help to draft those provisions of the agreement, to strike bad provisions in there, and to support your efforts to make this purchase or make this sale while minimizing your own risk. So if you have questions about any of that, please feel free to give our office a call. We're happy to help.